Hi friends from around the world. Here we are with a heavy agenda for today, still on patents. So there is some left over from the last video, which is on the enforcement of the European patent managed by the EPO, right? So that European patent, if you're not satisfied with the decision received by the European Patent Office, you can go to the appeal stage, which is an administrative instance located at the EPO, but with independent criteria. So they are not bound by any, order by the president of the EPO to rule in one sense or the other. So they're independent in their assessment. So this is the administrative, and then it stops. So there's no court behind afterwards. This is a bit astonishing, thinking that the patents are a bit more complicated. There are still some heavy and important IP right, but I am not aware that there were a lot of complaint by the patent holders that this court proceedings afterwards are missing. It may be that the lawyers think afterwards, but these are lawyers. They like litigating, and they had not this possibility so far. So that is on the administrative side, right? Now on the judicial side, the possibilities of enforcement existed only in national courts. There are national courts which are, so to say, specialized in IP rights. In Germany, for example, we have specialized IP courts. So they have some idea, although the rules they apply are member states' rules. So injunction, etc. So it must be according to the member state, and who knows the 27 laws of the member state. So it is a bit complicated, the enforcement there. So this is about the European patent, and I will go now to Unitary Patent and Unified Patent Court. So these are two different things, two regulations. One is the Unitary Patent, another is the Unified Patent Court. Ideally, they would come together and would naturally then be implemented both at the same time, because they serve at the same purpose, the overall unitary patent, right? So what is it? The basic idea, very easily, and you will grasp it easily if you're a business owner, and precisely if you know what I have talked to you about trademarks and designs. A unitary patent is one title only for the whole European Union. The European patent, I told you before, is one filing, but at the end results 27 individual patents, right? So one title for the whole European Union. And you have the possibility to go to court afterwards, whereas now this is not the case, right? I just told you a moment ago. You can go to the court, and you go to specialized courts, so to the Unified Patent Court afterwards, if you are not happy with the decision of the EPO. I will come to that. Or if you want damages or injunction relief, or if you want information from the other party about your damages, etc. So this is all through the Unified Patent Court. So that is the basic idea. You got it, right? Easy. Well, not so easy apparently, because we are waiting for this now for some 40 years. Why we're waiting for 40 years? Because the negotiations started a long time ago. So the European patent, they came in the middle and relieved a bit the pressure from going forward. But still, well, we are not there yet. At the heart of the problem now is Germany. The problem is that Germany has to present the full ratification proceedings in the internal process of Germany, and then it would be notified to the Commission, and then it can go live. So this is not, we are not yet there, and you know, in Germany they have some elections having, and you know, the formation of the government, so it takes probably some time. I suppose mid 2022 that would be a moment where this can go live. So this is the situation at this moment. Now let's go a bit into the unitary patent. What I told you about the European patent was, one word, there is the European phase, right? And there is the national phase. Okay, you got this? European phase, national phase, that was for the European patent. And you got 26 or 27 individual titles. Well, you get a bit less because the Benelux, there's only one title. But anyway, don't mix it too much up. Now, the unitary patent is also managed by the EPO, so by the same agency. It's a big agency. They have 9,000 employees, so a very big one. And they are scattered in Munich and in The Hague and in Vienna and Berlin, so they're a bit all over. Now, they manage the examination, and it is the same examination which would be done for the European patent. So, in fact, at the beginning, you don't have to decide whether you want one or the other, because it is all the same. Just 1 month before the grant of the European patent, so the provisional grant if you want, then you have to decide you want a unitary patent or you want a European patent, and then you have to designate the necessary member states for the European patent, if you want so, right? In fact, you don't have, if you don't decide anything, don't say anything, then the unitary patent is supposed to be required by you. And you have only, so to say, an opt-out if you want a European patent. So, you see, with the European unitary patent is European phase, national phase. The European unitary patent, the unitary patent now, the unitary patent, they stop at the grant of the patent by the EPO. So at the end of the European phase. So you don't need to go into the national phases, right? So that is a big issue. Now, what are the results expected from the unitary patent? Well, the first thing is on the languages. We have a different language regime. So, whereas for the national phase you needed to translate into the different national languages the patent application, the description, the justification, the prior art, etc. You have to translate everything into the national language, and here you do not need this. You present the filing, the patent filing, in English, and yes, you have to present it in the other two languages of the EPO, which is French and German. But that's it. That's it. And further on in the future, once machine translation becomes sufficiently reliable, then you will only need to present a machine translation for the other two languages. And machine translation, so there is a patent translate application on the website of the EPO where you can use this machine translation. This will be improved over time, and by as a maximum of 12 years, so you can present machine translation. I think it will become much earlier. For the time, so as the national phase is not anymore necessary, so to say, you expect that it will become quicker for you. And this is my hope as well. So if it takes 2 years, and 2 years is something, in order to get a European patent so far, I think, well, I don't know whether we can see 1 year or so as an average for granting that patent. In any case, it will be less than before because there's less work to do. Now, on the cost, what about the cost? Well, this is one important issue. I told you for the European patent it was 40 to 50,000 euros what you need for the filing, and then afterwards you need also the yearly fees to be paid, maintenance fees, so to say, for the patent year after year until year number 20. So 40 to 50,000 for the filing. So this will drop probably to some estimated, give it or take it, 5,000 euros. But this is nearly 1/10 of what it has been, of it used to be. So that is quite a substantial drop. And then what you have for maintenance fees, the cost for the unitary patent will be 35 euros for the second year, and it will go up to 4,855 for the year number 20. It go exponentially higher, right? That is a difference with regard to the trademarks and designs, where you have only one payment at the beginning and then until renewal. So after 10 years or after 5 years for designs, then you have not to pay anything. Here it is different. In patent, you have to pay. Okay, and what about the quality? If it is much cheaper, what about the quality? You are right to ask. Well, I think the EPO is committed to quality, so that is one of their main focus, to make a quality examination and look for prior art, so to say, whether there is or not. Now, the quality, I think, will be maintained the same. So you will get a same patent which is quite stable. There is a possibility of invalidity by third parties, yes, that always exists, but it is a quite stable one because the examination from the outset by the examiner at the EPO is very substantial. So this is it about the unitary patent. Can you switch, by the way, from the European patent to the unitary patent? No, you cannot. That is not possible, so you have to stick with it. And will you still wait now for the unitary patent rather than filing now for the European patent? Well, you know the first to file, right, and the prior art. So if you are sure you will be prior art within a year or so, you have something new next year by October or so, well, then you may want to wait for the unitary patent, although it is not clear if we have it by then. So my advice would be not to look too much to the unitary patent. You have something which is already ready to file as a patent, which has all the ingredients you need in order to get the protection. Go for it. That would be my advice. Now, in general, just for strategic, I will just mention that normally the rough, the thumb, the rough the thumb rule would be that if you want protection for 2 countries, so it's easier to take the national route. If you want more than 3 countries, then you take the EU route. So the European trademark, the European design, or the unitary patent in this case. So that is the rule of thumb. That was it. Okay. So what is now previous to filing? Some words on previous to filing. So I'm very much on due diligence and to look for prior art, and where can you look for prior art, etc. So this is also being solved by the European Patent Office. They have a database with 100 million, I think, documents to look for, and they have a search facilities. So there you are able to get a lot of information out, and if you're, well, it is the same database which are used by the examiner, so why should not you be able to get a first look into that one in order to exclude what would be an obvious rejection. So you don't want to be rejected, obviously, right? So that would be my advice in order not to go blindly into a patent filing. Now, at the end, the Unified Patent Court. So the Unified Patent Court is a new court being established, is a court which has its headquarters in Paris and a branch in Munich, probably another branch somewhere else. They wanted to put it in London, but due to Brexit, so London is out. So we need to locate this somewhere else. I think Slovenia is on the, I don't know where it is. Now, this branch is according to, one is for mechanics, another is for chemistry or whatever. So it is a bit in that sense. Headquarters is in Paris, and the, so to say, appeal court, the second instance, is in Luxembourg. That's the European Court of Justice. So this Unified Patent Court, they are members, citizens from all European Union, as in the European Court of Justice. So it is something where unitary and European law is applied, and European law practically only. And you can go to this court not only for the invalidity, you can go for the invalidity of the patent to the EPO, or you can go to the Unitary Patent Court directly, Unified Patent Court directly. But also all the other possibilities, the damages, the information claim, the injunction relief, so all this kind of proceedings is being carried out by the Unified Patent Court. So what is the good thing is that we have now a Unified Patent Court, because the rulings of all the national courts applying national law, are they consistent? No, they are not consistent. Do we know the law of each member state in order to litigate comfortably? No, we don't know the law of all the member states. So we want to have a kind of framework which we know, which we can work with, and which is previsible with regard to the results. And the Unified Patent Court, well, it promises us they will have to make some case law in order to get the trust of the community, of the lawyers, of the patent holders, etc. But they will go through, and at a certain moment we get clarity on what is being the decision and the case law and the view of the court. So let me wrap this up very quickly. We talked about the unitary patent, how it will work, more or less, and we talked about some strategic issues and about the Unified Patent Court. So the takeaway for you is that unitary patent will come, one title, 27, 26 member states. So Spain is still not clear whether it will come in, jump into the basket of contracting states. There's they were reluctant with regard to the language. On the WIPO, Spanish is an official language, and EPO it is not. So they wanted that Spanish also being a language, working language. But then we have Italy as well, so it was a mess. So Spain is out for so far, but it may join later. Wow, that's it. Thank you for tuning in.